Ready, start. The appellant was, thus, held guilty also of causing the knife injury to Rakesh and came to be convicted under section 324 in addition to section 302 of the Penal Code full stop. Under section 324, he was sentenced to rigorous imprisonment for 1 year full stop. He was also convicted under section 25 of the Arms Act by a separate judgment of the trial court dated February 2, 1998 in Sessions Case number 1 of 1993 and sentenced to the period of imprisonment already undergone as under trial full stop. Against the two judgment of the trial court, three appeals were filed in the High Court full stop. The High Court by the judgment and order coming under appeal dismissed all the three appeals and revision and thus, upheld the judgments of the trial court in all aspects full stop. Mr. Sahai, senior advocate, appearing for the appellant, assailed the High Court and the trial court judgments and contended that the appellant's conviction for the offence of murder was not sustainable both in law and on facts full stop. Mr. Sahai submitted that there were at least four circumstances that falsified and completely demolished the prosecution case full stop. First, there was a patent contradiction between the prosecution case and the motive assigned by to it the accused for committing the crime full stop. Secondly, it was undeniable that injuries were fabricated both on the person or the deceased and Rakesh full stop, the only eyewitness whose evidence was accepted by the High Court full stop. At the time when the plea was raised before the High Court that the impugned orders are violated on account of the non-supply of inquiry report full stop, it would have been appropriate for the High Court to examine the averments made in the writ petition full stop. A perusal of the writ petition would show that the petitioner has failed to lay any foundation to establish that any prejudice has been caused by the non-supply of the inquiry report full stop. No prejudice was actually caused to the respondent full stop. There was no failure of justice in the facts and circumstances of this case by non-supply of the inquiry report to the respondent full stop. The punishment imposed on the respondent cannot be said to be disproportionate to the gravity of the charges proved against the respondent full stop. The charges related to the conduct of the respondent in a financial institution whereby he procured pecuniary benefits for himself full stop. Further, SSE markets the agricultural produce of its members full stop. It retains the sale proceeds in many cases full stop. It is this retained amount which was payable to its members full stop, from whom produce was brought, which was invested in short-term deposits and securities full stop. Such an amount, which was retained by the SSE society, was a liability and it was shown in the balance sheet on the liability side full stop. Therefore, to that extent, such interest income cannot be said to be attributable either to the activity mentioned in section 80p of the Act full stop. Therefore, looking to the facts and circumstances of the case, the assessing officer was right in taxing the said interest income, under section 56 of the Act full stop. To say that the source of income is not relevant for deciding the acceptability of section 80p of the Act would not be correct, because weightage needs to be given to the words the whole of the amount of profits and gains of business attributable to one of the activities specified in section 80p under bracket 2 under bracket a of the Act full stop. The words the whole of the amount of profits and gains of business emphasize that the income is respect of which deduction is sought must constitute the operational income and not the other income which accrues to the society full stop. As regards validity of the notice under section 148 of the Act to reopen the assessment is essentially concerns factual aspect full stop. The tribunal is the final fact-finding authority under the Act full stop. It has given a finding of fact that through the written communication of the sanction, which has no prescribed format, was received by the assessing officer on 8th June, 2001, but, the approval or under section 4 reopening of assessment in terms of section 148 of the Act read with Section 151 existed even prior to 31st May, 2001, full stop. There is no reason to interfere with this finding of fact given by the tribunal, full stop. In the instant matter, the question whether on the facts and in the circumstances of the case, the tribunal was right in law in holding that the income by way of interest on deposits held with scheduled banks, bonds and other securities was chargeable to tax under section 56 under the head income from other sources without allowing any deduction in respect of cost of funds. Full stop. Stop.